Marriages out of community of property with the application of the accrual system. The accrual system provides that at the dissolution of a marriage, subject to the accrual system, by divorce or by the death of one or both of the spouses, the spouse whose estate shows no accrual, or a smaller accrual than the estate of the other spouse, or his estate if he is deceased, acquires a claim against the other spouse or his estate for an amount equal to half of the difference. The accrual system, which was mainly designed to protect the spouse whose estate during the marriage did not grow substantially the same as compared to that of his or her spouse, allows a spouse with a smaller estate to claim a share in his or her spouse's estate, which showed greater or substantial growth. The term accrual is therefore used to denote the net increase in the value of a spouse's estate since the date of marriage. In other words, what was yours before the marriage remains yours, and what you have earned during the marriage belongs to both of you. Because the right to share in the accrual is exercisable only upon dissolution of the marriage, such a right is not transferable. It cannot be attached by creditors during the subsistence of the marriage. Looking at a system in more detail, it can be said that a system also functions as a deferred community of gains, meaning that during the subsistence of the marriage, it is out of community of property and community of profit and loss. Each spouse retains and controls his or her estate, but on the dissolution of the marriage, the spouses share equally in the accrual or growth of the estates have shown during the subsistence of the marriage. All assets owned by the parties before the marriage can either be excluded or included in the accrual. Assets that the parties wish to exclude should be excluded expressly in the antenuptial agreement. Should the parties elect to exclude no assets, the values of each party's estate at the commencement of the marriage is deemed to be null, unless